Here's the second exception to the no third-party standing rule, and it reveals something important about how courts decide which rights matter. You can sue on behalf of someone else if they face practical obstacles that prevent them from asserting their own rights. Sounds technical, but look at how it played out. 1958, the NAACP v. Alabama case. Alabama demanded the NAACP turn over its membership lists. The organization refused and sued, claiming it violated members' First Amendment rights to anonymous association. Alabama said, "Let your members sue them." And here's the problem. If members sued individually to keep their name secret, they'd have to publicly identify themselves in the lawsuit. They'd expose themselves to the exact retaliation they were trying to avoid. It's a perfect catch-22. You can't sue without suffering the harm, and you're suing to prevent that harm. The Supreme Court said this is absurd. The NAACP could sue on behalf of its members because forcing members to sue individually would deny the right entirely. This is the hindrance exception. When the actual rights holder can't practically sue, someone else can do it for them. Another example, Barrows v. Jackson in 1953. A white property owner challenged racially restrictive covenants on behalf of black would-be purchasers. The court allowed it because black buyers couldn't sue without first trying to buy and being rejected, forcing them to suffer discrimination before challenging it. And abortion cases. Roe v. Wade recognized that pregnant women couldn't maintain lawsuits through years of appeals. By the time the case reaches the Supreme Court, they're no longer pregnant. The case becomes moot. So abortion providers could sue on behalf of patients who face this practical impossibility. This exception sounds like it protects people facing real obstacles to justice. But watch how selectively it gets applied. The NAACP case involved physical threats to black activists in 1950s Alabama. The court recognized that insisting on normal standing rules would effectively destroy the right. But modern surveillance plaintiffs face the same catch-22. You can't prove the government spied on you without disclosures that would compromise national security. Courts rarely allow third-party standing there. Abortion providers could sue because of the mootness problem. That practical obstacle didn't change after Dobbs. Pregnant women still can't maintain litigation through appeals while pregnant. But some courts now argue doctors don't have standing anymore because abortion isn't constitutionally protected. The hindrance didn't disappear, the court just stopped caring about it. Poor people face obstacles to litigation all the time. They can't afford lawyers, they fear retaliation from employers or landlords. Immigration status makes them vulnerable. Courts don't usually find those obstacles sufficient for third-party standing. But abortion patients facing stigma? That's different. The exception exposes the truth about the standing doctrine. It's not really about ensuring concrete adversarial litigation. If it were, courts would consistently recognize when practical obstacles prevent rights holders from suing. Instead, they recognize obstacles when they want to hear the case and ignore them when they don't. The hindrance exception should open courthouse doors for people facing real barriers to justice. Instead, it's just another tool for judicial gatekeeping. Courts decide which obstacles count and which people deserve someone to sue on their behalf. It's not about protecting rights. It's about controlling access to federal courts.